Good day, Crime Talk aficionados. We have a great show for you today. First, Karen Reed wants her case dismissed because of prosecutorial misconduct. Bryan Kohbergers are arguing that he shouldn't be eligible for the death penalty because he's autistic. Donna Adelson wants to get released from jail because she thinks there's some mean people in there. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and yes, hit that little bell for notifications. Now, you can also listen to us on any of your favorite podcasting apps. Now, as you can tell, I am not in the Crime Talk studios today. I am in a conference room at a local courthouse. It's been one of those days where I thought I'd be in and out. And like 3.5 hours later, when I got my case called up, so it's a little frustrating. The whole day has been pushed back. So I've actually never made it to the office today. But that's what sometimes things go on in life and in the practice of law. And you just simply have to adjust. So before we get to the docket, remember to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you're going to be able to do as many background searches as you desire. The results will literally be sent to you while you wait, and you're going to get all kinds of information about the person you are searching about. Do they have a criminal history? Are they on a sex offender registry? Do they have a social media presence? Why do they have 25 emails that they never tell you about? Is it because they're on all those dating apps? Go to crimetalksearch.com and find out. You're going to be happy that you did. All right. So let's go ahead and get to the docket for Thursday, February 27th, 2025. And first on the docket, what do we have? Karen Reed. Now, there's been a lot of talk about the Karen Reed case over the last several weeks because, well, there's allegations that the defense engaged in some serious misconduct that could result in the lead attorney, that's right, Mr. Jackson, for the defense being dismissed or having his ability to practice in the Commonwealth of Massachusetts revoked under the Pro Hoc Vice standard. So, not to be outdone by being accused of misconduct, the defense has said, we are going to file a motion saying that there is prosecutorial misconduct. So let's quickly go through it. It's 147 pages long. Some of it's been redacted. I'll have more time to go through it tomorrow. But like I said, as we noted, the defense team is asking the judge in the Karen Reed case to dismiss the entire case because of what they refer to as extraordinary governmental misconduct. Now, Reed's defense team has kind of been hinting that they're going to file something, but they finally got around to it. A lot of it was sealed, but now it's been unsealed with portions of it redacted. So the heavy redacted version of the 147-page document was released today. Obviously, some critical evidence, not disclosing meetings with witnesses and interfering with the jury. Now, Reed's lawyers, like I said, say that the case should be thrown out with prejudice, which means that the prosecution could not refile the case because of, well, if there's this alleged misconduct that took place. Now, the defense argues that Ms. Reed has been permanently and irreversibly denied her constitutional right to a fair trial. And obviously, the only possible remedy would be dismissal of the case, according to Ms. Reed. Now, a kind of theme that runs through the motion is the issue of video surveillance at the Canton Police Department. Now, as you may recall, during Reed's first trial, the state police sergeant, Sergeant Buchanek, testified about a Sallyport video showing Reed's car inside the police station. Apparently, the video was inverting. Now, in that motion, the defense attorneys say that the inverted video was a deliberate attempt to defraud the jury into believing that no one approached or touched the right rear taillight because part of the defense, obviously, allegation is that Trooper Michael Proctor manipulated the taillight and planted evidence at the crime scene. Now, the defense attorneys also say the video footage never was disclosed until April of 2024, shortly before the first trial, despite an order from the courts to preserve that evidence. In addition, the attorneys took issue with the fact that the 42-minute video in the Sally Port is missing, and the exact time they say Reed's car could have been driven into the garage, showing the condition of her taillight, which they say would show whether anyone removed the taillight material from the SUV before the first piece of taillight evidence was recovered at 34 Fairview Road. Now, on October 10th of 2024, after the first trial, defense attorneys say they received new footage from the police that shows a witness, Brian Higgins, in the parking lot of the Canton Police Department making a phone call to an unknown individual at approximately 1:34 a.m. Defense argues that the Commonwealth failed to preserve video in that case, which they were required to do under the February 2, 2022 preservation order. In addition, more Canton police video released to the defense in January 2025 shows blurry and grainy footage showing an unidentified individual approach the right taillight. The defense didn't have access to the video during the first trial. Now, no taillight material was found at the scene until the Massachusetts State Police took custody of Miss Reed's vehicle and after it arrived at the Sally Port. It is not a coincidence that none of the cameras in the Sallyport garage captured the condition of the right rear taillight upon its arrival there at the Canton Police Department, as the defense is alleging. Next, Jen McCabe goes to Michael Lank's house. It was revealed at Miss Reed's first trial that witness Jennifer McCabe made a visit to the Canton police officer Michael Link's house the day after John O'Keefe's death. McCabe says she was dropping off a friend's daughter and didn't go into the house other than use the bathroom. That allegation is in dispute. Anyway, Lank was the first officer to go into the 34 Fairview Road to speak with the witnesses at the scene. The defense attorneys, in their motion to dismiss, alleged that the prosecutors and the state detectives were aware of the visit by Miss McCabe on May 10th, a full week before she testified in the Reed's case, but never informed the defense despite their legal and ethical obligation to do so. You can kind of see this tit for tat. Ooh, we're in trouble for ethical violations. Now we're going to say you did ethical violations. Now there's a new allegation of jury tampering, never heard before by the public, but defense attorneys allege the juror tampering by the prosecution during Miss Reed's first trial. Specifically, the motion implies that a juror was dismissed because of their views. Several jurors were dismissed over the course of the trial, including one dismissal that morning and closing argument. Despite the allegations of jury tampering, we can't know the specific details of which juror is the center of the controversy or why the description of the allegation is redacted, obviously with no public access. Ultimately, Ms. Reed's Sixth Amendment right to an impartial jury entitled her certain procedural protections when it comes to the dismissal of jurors, and those procedural protections were not provided for, Ms. Reed alleges. There's a lot more redactions. The majority of the exhibits attached to the motion to dismiss are redacted, showing fully inked out pages that are inaccessible by members of the media. I mean, literally blacked out. The redaction of the entire pages, a sequential series of pages or entire documents, is usually questionable in terms of the free flow of information to the public, media, and we're entitled to take a look at those. It's a little unusual that they redact out so much information. It's rather frustrating. Like I said, we're all adults. We're all big boys and girls. We can handle it. So anyway, the prosecution's obviously going to be given a opportunity to respond to this. Frankly, I'll be honest with you. I'm going to go through the entire 127-page affidavit in much greater detail than I did today. But most of these issues have already been dealt with by the court. Other than the issue of perhaps knowing that a witness was at a particular house and it wasn't disclosed, well, it should have been. Is dismissal the appropriate remedies? You'll hear the judge say when she rules on that dismissal is an extreme sanction and should only be done in the most egregious of cases. A lot of this is rehash of what has taken place before, and anything related to juror misconduct would have been dealt with by the judge. I think this motion is going nowhere. The defense team needs to focus on their problems as it relates to the misrepresentations to the court. And obviously, Mr. Brennan, the prosecutor on this case, he inherits it and he's going to be responsible for anything that the previous prosecutors did. But the reality of it is it wasn't his involvement. I think this motion is going nowhere. We'll see what the prosecution has to say, but I think their analysis is going to be the same as mine. So I know I'm ready. Bring it on. All the Karen Reed people that think that she can do no wrong and that there's prosecutorial misconduct everywhere, let me hear about it. Okay. A lot of this has been dealt with. The court dealt with it previously, saying, hey, unless you can show bad faith, unless you can show some video was destroyed or tampered with intentionally, then you don't have an issue regarding that. But this is a good learning lesson for the prosecution and the police to show that, hey, you need to handle your business professionally and competently, because otherwise it makes it look like, one, you're incompetent, and two, that you're trying to cover something up. So it's a good lesson. But that goes to the weight of the evidence at trial. I just don't see it as a basis for a dismissal. Next on the docket, let's talk Bryan Kohberger. Now, remember, Bryan Kohberger is obviously charged with the quadruple homicide and a burglary there in Moscow, Idaho, going back in November of 2023. Trial is supposed to begin later this summer, and defense has been constantly trying to get the death penalty taken off the table. That's what any death penalty attorney tries to do. Like I said, I've only done one death penalty case. We got them to take death off the table. At that point, you're like, okay, we won. All right. The motions didn't exactly go the way the defense was hoping. Frankly, it was kind of a new area of law. Not sure the law is there just yet. And that's why all of their motions were denied, which means the DNA, all those orders, the GPS data, the phone records, they're all coming in for Bryan Kohberger. And I said, they're going to start talking plea bargain in this particular case. We also know that the prosecution filed a motion the other day saying, hey, any psychiatric or mental health evaluations that are done should not come in to somehow try to negate the mental element. Okay. So there's been information that Bryan Kohberger is trying to strike the death penalty because apparently there's been some evaluations of Bryan Kohberger that he is on the autism spectrum. And he has an autism spectrum disorder, according to a summary of court documents filed in the case. Now, once again, I hate to always sound like the skeptic, but this is good lawyering. But it's not going anywhere. All right. Let me tell you why. Listen, if everyone that had a mental health issue or a drug issue or something that made them act silly or not like everybody else, so to speak, no one would ever be prosecuted. It's not a defense. And only people that the United States Supreme Court has said you cannot bring forth capital murder charges against them are people that are severely mentally disabled. It used to be called the R word. Was your IQ below a 50 kind of thing? Bryan Kohberger was a PhD student, ladies and gentlemen. Do you really think that if he has autism, that somehow would affect his ability to know right from wrong? It's not a mental health insanity type defense. It doesn't negate anything. I said, I'm a defense attorney. I would love for this to be, litigated in court and see where it goes. But I think this is another nothing burger by the defense. They're trying to get the death penalty off the table. They tried to do it privately. Now they're trying to do it publicly as it relates to trying to present their mitigation to the public, because apparently it's falling on some deaf ears over there at the district attorney's office. Next on the docket, Donna Adelson. Remember her? The alleged mastermind in the murder for hire of her former son-in-law, former FSU law professor Dan Markle, who was shot and killed in his driveway. Well, her son, Charlie, has already been convicted for his role in the plot, and along with Charlie's ex-girlfriend, Catherine Magbuana, and along with two other men. Anyway, Donna was obviously arrested and is in custody, and she was just about ready to get away to Vietnam, where they didn't have an extradition treaty to bring her back. But as she remains in custody, well, she would like to get out of custody. So there was a hearing that was held to see whether she should be given a bond of some type. because while she's been in custody, she has been assaulted several times, and she doesn't like it, and she would like to go home. Anyway, like I said, she alleged, as she testified in the stand, that she was assaulted multiple times, first time being in the shower. Apparently, all of a sudden, she felt a hand go up her back from the top of her butt, and she apparently started to cry, and when she screamed, the inmate ran away. On another occasion, another lady said, unless you want your pretty white teeth knocked out, you're going to buy me some commissary. Ms. Adelson would not name the woman other than describing her as a big woman. Anyway, Ms. Adelson also described a bunch of medical issues that she is facing, including sciatica, earwax buildup, earwax buildup and sciatica. Okay. Motion for bond reduction denied. You are a flight risk, Miss Adelson. You're not going anywhere. The only way you're going to go anywhere is if you are found not guilty. Anyway, the judge reserved ruling, but I'm telling you right now, denied. Jail is a dangerous place, ladies and gentlemen. There's lots of people in there that don't like to follow the rules. There's a lot of people in there that kind of goes back to old, kind of the survival of the fittest, strongest rules, so to speak. Maybe not the world that Miss Adelson is used to, but she better get used to it. She's a flight risk and a danger to the community. She is not going anywhere. All right, next on the docket, this day in legal history. First, on February 27th, 1875, Congress passed the Civil Rights Act of 1875, and its goal was to guarantee African Americans equal treatment in public accommodations, public transportation, and the right to sit on a jury. Although the Supreme Court declared that act unconstitutional in 1883, but obviously it led to future civil rights legislations in the future. On this date in 1922, the United States Supreme Court unanimously upheld the 19th Amendment, which granted the women the right to vote in the case of Lesser v. Garnett. That's right. Some people actually did not want that. Obviously, that decision reinforced women's suffrage and solidified the constitutional amendment's authority. On this date, February 27th, 1951, the 22nd Amendment to the United States Constitution was ratified, limiting presidents to 2 terms in office. This amendment formalized the tradition of a 2-term limit, influencing the structure of the U.S. executive leadership. Now, if we can only get one for members of Congress. And then finally, our dumb criminal of the day. Please meet Evelina Fabinski. Now, take a look at some of her handiwork here. Look at what she did to this car. Yeah. She probably had a good reason to vandalize somebody else's car. For example, I don't know, it could have been an old boyfriend's car. That's who she thought it was. She was vandalizing along with a juvenile because of a debt that the former boyfriend owed. But guess what, Miss Fabinski? You got the wrong car. Ooh, ouch. That's right. She caused over $5,000 of damage to a person's car that she didn't even know. Oops. But she did write the words Jason and Devil on the car in yellow paint. You got to love that. Needless to say, Miss Fabinski, need to try a little harder when you're going to try to damage somebody else's car, particularly your ex-boyfriend's. And anyway, she faces 4 counts of misdemeanor criminal mischief. And there's also a felony charge of criminal mischief because the damage exceeds $1,000. So not only did she not get the money from her boyfriend, she didn't damage her boyfriend's car. She got arrested. She's facing a felony conviction, and she's going to have to pay for the car. Miss Fabinski, you are our dumb criminal of the day. Congratulations. You made it. You can put that on your resume. I'll even vouch for you. I'll write you a letter of recommendation because you're dumb. All right. That's all we have for today, ladies and gentlemen. Hope you enjoyed the show. Have a wonderful day. We'll be back in the studio tomorrow. And remember, the Constitution matters.